2 years of silence had produced a documentary record that would have taken a careful reader the better part of a week to fully review. Diane's attorney sent a formal demand letter in December 2022. 4 pages. Detailed accounting of every fine and fee issued since January. Total demand, $22,000. If not paid within 30 days, civil action would follow. I forwarded it to my attorney the same afternoon. Her response to Diane's counsel was 2 sentences. Our client disputes all charges and reserves all rights. We look forward to further correspondence. There are nights in every long fight when logic stops working. I knew the easement was valid. I'd had it reviewed by a licensed attorney with 27 years of property law experience. I'd pulled the county record myself and read every word. But at 2 in the morning in December, with a $22,000 demand letter on my kitchen table and a civil action threat behind it, the questions arrived anyway. What if there was a technical flaw in the original filing nobody had caught? What if the 1963 recording had an error in the legal description? What if 61 years of waiting had been built on a document with a crack in it I simply couldn't see? I got up before sunrise, drove to the county clerk's office when it opened, and requested the original microfilm for the 1963 deed recording. The clerk threaded it through the reader and left me alone at the lamp. I found the document, read every line of it under that light, and there in the margin, in my grandfather's careful handwriting, was a notation he had added the day of recording. Recorded this day in good faith for the protection of this land and all who come after. No cracks, no errors, solid as the granite shelf at the water's edge. I drove home, slept fine that night. In January 2023, the HOA issued a press release announcing the final 2 membership closings for March 14th, describing the development as a landmark achievement for neighborhood-driven development. I folded it and added it to the folder. My attorney and I had been working on a document of our own for several weeks, a formal notice of easement violation and demand for remediation. A legal instrument that once served would place the HOA, Diane personally, and every party connected to the development on official notice that the construction violated a recorded easement and that remediation was being demanded. It was thorough. It cited every permit number, every construction phase, every specific provision of the 1963 easement that had been breached. We didn't file it. We set it aside and waited. I also contacted the State Department of Environmental Quality that month, directly, myself, with a written submission and a documentation package I had been assembling for over a year. Photographs of the rerouted drainage corridor with GPS coordinates. The county habitat map showing the designated corridor and the survey overlay confirming the removed trees. Permit records showing no shoreline impact permit had been obtained for the concrete boat launch. The DEQ acknowledged receipt and opened a preliminary inquiry within 2 weeks. I didn't tell anyone, didn't mention it to neighbors, didn't reference it in any correspondence. It went into the record quietly, the way everything I had done for 3 years had gone into the record quietly. The last thing I did in February was call the title company handling the March 14th closings. I identified myself, gave my parcel number, and asked a routine question about a shared boundary line. The kind of question that required them to confirm the closing date and properties involved without raising any concern. Everything was in order. Both buyers confirmed. The HOA confirmed. Diane confirmed. Everyone was showing up. I hung up. Sat with that for a minute. I didn't set a trap. I just let them walk into what was already there. I was up before 6 on March 14th, showered, made coffee in my grandfather's tin thermos, put on a pressed shirt, the same one I had worn to my father's funeral 4 years earlier. I am not a superstitious man, but some mornings call for a certain kind of clothing. I drove to the county recorder's office when it opened at 8 and requested certified copies of the easement documentation with that morning's date stamp. I wanted the paperwork to be unambiguous about when it was pulled and by whom. Back in my car by 8:40, I arrived at the title company at 9:55 and sat in the parking lot. At 10, a young couple pulled in 2 spaces down, mid-30s, dressed carefully, the woman carrying a manila folder against her chest the way people carry things they've been told are important. Bright-eyed, moving with the energy of people who believe they're about to complete something good. 2 minutes later, a truck pulled in on the far side. The retired contractor, already shaking hands with the HOA representative on the front steps. Through the lobby glass, I could see Diane at the conference table. Leather portfolio, tailored blazer, the composed expression of a woman who believed the hardest part of the day was already behind her. I walked in at 10:02, asked the receptionist to let the title officer know I had a recorded document relevant to today's closings. The title officer, Ms. Patel, came to the waiting area about 4 minutes later. Exactly what you want in someone in that role. Measured, unhurried, the kind of professional who has closed enough transactions to understand that surprises at this stage are never small. She sat across from me. I handed her the certified copies without preamble. She read the first page. Her expression didn't change. She turned to the second page and read it with the same careful stillness. Then she looked up at me once, briefly, excused herself, and walked back toward her office at a pace that was professionally controlled, but slightly faster than the pace she had arrived at. I sat in the waiting area and looked at the wall. 10 minutes passed. Then Diane appeared in the hallway, smiling, the smile of someone in the middle of a good day who has just noticed what she assumes is a minor inconvenience. "Mr. Beaumont, here to cause trouble on our big day?" I looked at her for a moment. Then I nodded toward Miss Patel's office and said nothing. The smile held for a few more seconds through what appeared to be some effort. Then Ms. Patel appeared in the hallway behind her and asked everyone to come into the conference room. Both buyers, the HOA's attorney, Diane. Ms. Patel placed the easement document on the table. She didn't editorialize. She simply explained in the precise and neutral language of someone who understands that her job in this moment is accuracy rather than comfort. That the title search conducted for both properties had failed to disclose a recorded easement that materially affected the use and marketability of both parcels being closed today. The HOA's attorney picked up the document, read the first paragraph. Then he looked across the table at me. "Where did this come from?" "The county recorder's office," I said. "It's been there since 1963. Diane's voice came from the end of the table. "This can't be valid. We had a title search done." Ms. Patel turned to her. "The easement is recorded. It was not disclosed in the seller's title commitments. I cannot complete these closings today." The young couple looked at each other. That look carried the full weight of $78,000, and everything they had told themselves this purchase meant for their lives. The retired contractor already had his phone out before Ms. Patel finished her sentence. Within 48 hours of the halted closings, my attorney served the formal notice of easement violation and demand for remediation. 3 recipients: the HOA as an organization, Diane Harwick personally in her capacity as board president, and the regional bank holding the $2.1 million construction loan. 3 separate service packages, 3 separate cover letters, sent the same morning. The bank's legal team responded in 72 hours. That is fast for a financial institution, which tells you exactly how their attorneys read the situation when they reviewed the easement documentation. The construction loan was placed in technical default pending legal review. The bank had lent $2.1 million against collateral whose value was premised entirely on the commercial structures built on that shoreline. They had just been formally notified that those structures existed in violation of a recorded easement their own due diligence had failed to identify. The collateral hadn't physically changed, but its legal standing had. And a loan secured against compromised collateral is a loan in serious trouble. The same week, the DEQ formally elevated its preliminary inquiry to an active investigation. The rerouted drainage corridor was confirmed to violate state wetland buffer protection statutes. The concrete boat launch had been installed without the required shoreline impact permit, a permit that, had it been applied for, would have triggered an environmental review that would almost certainly have stopped the project entirely. And the 11 white pines removed from the eastern bank were confirmed as part of a county-designated habitat corridor, meaning their removal carried individual per-tree penalties under local environmental ordinance. Here's what that combination means legally, and this is important. When environmental violations are layered on top of easement violations, the liability doesn't simply add together, it compounds. Courts have increasingly recognized what they call a pattern of environmental disregard as grounds for enhanced damages, particularly when a commercial enterprise was the direct financial beneficiary of those violations. The HOA was no longer facing a property boundary dispute. They were facing environmental remediation costs, lender default exposure, and the very real possibility of personal liability for every board member who had signed off on any phase of this development. My attorney filed the easement violation case in County Circuit Court in April of 2023, requesting a preliminary injunction halting all commercial use of the 14 cabins pending full resolution. To obtain a preliminary injunction, you have to demonstrate a likelihood of success on the merits. My attorney believed we could demonstrate that. She was right. The local news picked up the story within a week. The regional paper ran it on the front page. The headline: HOA built $4.2 million lakefront development on disputed land. Owner says he held the rights all along. It was the first time most people in the county were hearing any of it. I had been quiet for 3 years. The silence was over. Diane issued a public statement. I'll credit her for consistency. She had been underestimating me since 2021 and wasn't about to stop. This is one man's attempt to punish his community for improving itself, she said. The easement he's citing is 60 years old and has never been enforced. My attorney responded in the same article with one sentence. Easements do not expire through non-enforcement. That is not how property law works. The hearing was held 3 weeks later. Diane's attorney made 2 arguments. First, that the easement language was ambiguous. Second, that decades of HOA activity in the general area had constituted an implied modification of the original restrictions. Both arguments were presented with professional effort and real confidence. The judge had been on the bench for 21 years. He let Diane's attorney finish. Then he asked one question. Was this easement recorded with the county? The answer was yes. He granted the preliminary injunction. All 14 cabins were ordered to cease commercial operation immediately. 14 people who had each paid $78,000 were now holding a membership in a development that could not legally rent a single unit, host a single guest, or generate a single dollar of the promised income. The HOA's projected $280,000 annual rental revenue disappeared overnight. I walked out of the courthouse. A neighbor I hadn't spoken to in months fell into step beside me. Neither of us said anything at first. After a while, he asked if I felt like I'd won something. I didn't want this, I told him. I wanted them to read the deed. That's all I ever wanted. The injunction gave the 14 membership holders time to start asking questions. Up until that point, most of them had been assured in various ways that the legal challenge was just one difficult neighbor making noise and would be resolved quickly. A court order stopping operations entirely made that framing impossible to maintain. People who had been patient became people who needed answers. A group of 8 of them pooled resources and hired their own attorney, not to fight my claim, but to investigate what Diane had known about the easement and when she had known it. That is a different question than whether the easement is valid. It's a question about intent, about deliberate concealment, about whether the people who sold those memberships had done so knowing the development was built on legally compromised ground. Discovery produced documents. It usually does. What it produced in this case was a record showing that Diane's Lakefront Development Committee had reviewed the original property survey for the Eastern Bank parcels in the spring of 2019, before a single permit had been filed, before a single foundation had been poured. That survey contained a notation referencing the recorded easement. It was not hidden. It was not obscure. It was there in the document her own committee had reviewed and signed off on. And then there was the email, produced in discovery, sent by Diane to the permit expediter she had been working with to move construction applications through the county system. The relevant line read, "Let's not flag the Beaumont easement issue with the county. It's old and no one's going to chase it." When that email was presented at a subsequent court hearing, someone sitting in the public gallery was quoted in the newspaper as saying, "The judge's expression changed in a way that was very bad for the HOA." Diane resigned from the board 2 days after the email became public. She issued no statement, did not address the membership holders, the neighbors, or the press. The white Range Rover was gone from the neighborhood by the end of that week. The Crestwood HOA parking placard went with it. The circuit court issued its ruling in September of 2023. The judge ruled in my favor on all primary claims, every one of them. The 1963 Shoreline Easement was declared valid, properly recorded, and fully enforceable. The 14 commercial cabins constituted a material violation of the easement's express terms. The rerouted drainage corridor was ordered restored to its natural path within 18 months under DEQ supervision, at the HOA's expense. The concrete boat launch was ordered removed within 90 days. The damages award was $187,000, covering the destroyed white pines at mature habitat value rates under County Environmental Ordinance, documented interference with my shoreline access across the construction period, and 2 years of accumulated legal fees. Separately, the County District Attorney's Office opened a fraud inquiry against Diane personally. The basis was the deliberate concealment of the easement in the permit applications. Submitting applications that omit material encumbrances on the subject property is not a paperwork oversight. It is a knowing misrepresentation to a government body. That inquiry was ongoing at the time I recorded this. The construction loan moved from technical default into formal default proceedings. The bank began action against the HOA's general assets, the dues reserves, the road maintenance fund, the operating accounts. Every member of that HOA, including people who had nothing to do with Crestwood Shores and had simply been paying dues for years, was now financially exposed to the consequences of what Diane had built. A new board was elected in November of 2023. The new president was a retired civil engineer named Marcus, who had lived on the lane for 12 years and had never served on the board before because, as he told me, he'd never seen a reason to. He saw one now. The first official act of his presidency was a formal written letter of apology to my family, signed by every member of the new board, acknowledging what had been done to the property and to us over the preceding 3 years. That letter is in the Manila folder. 3 of the 14 membership holders had their purchase agreements formally voided due to the title defect identified at the March closings. Full refunds. The remaining 11 were in various stages of negotiation with the HOA and its insurers. The splinter group pursuing Diane personally for breach of fiduciary duty reached a settlement in early 2024. Terms not publicly disclosed, but 2 people familiar with the negotiation described the amount as substantial. And then there was Dave. He showed up at my door on a Thursday evening in December with a 6-pack and the particular expression of a man who has been working up to something for a while. He didn't make a speech. He just said he was sorry, that he should have known better, and that he missed fishing the way we used to. I told him I understood. We walked down to the granite shelf and sat by the water until it got cold. We didn't talk much. We didn't need to. The DEQ supervised restoration work began in the spring of 2024. Heavy equipment on the eastern bank, the same bank torn open by Diane's excavators 3 years earlier, now regrading the soil, reopening the natural channel, restoring the drainage corridor that had fed that cove since before my grandfather bought the land. I watched it from the granite shelf on the first morning they broke ground. It looked like repair. It felt like it too. 14 white pine seedlings were planted along the restored corridor that April. I planted the first one with my daughter. She brought a small spade and a camera and took a photograph of the seedling standing in the fresh soil with the cove behind it. That photograph has been my phone wallpaper since the day she sent it. The concrete boat launch came out the same month. The granite shelf was fully exposed for the first time in 3 years. On the first warm day of May, I walked down to the water and stood on it. The cove looked the way it looks in my grandfather's photographs from the 1960s. Not identical, but close enough that it meant something. You can't uncut a 60-year-old tree, but you can plant one and decide that it matters. That's what my grandfather understood in 1962 when he spent 2 extra hours at the county recorder's office before driving home. He wasn't protecting a piece of real estate. He was protecting a future that hadn't happened yet. I went back to the manila folder after the restoration was complete, opened it on the kitchen table, added 3 documents to what was already inside: the circuit court ruling, the DEQ restoration order, and a printed copy of the photograph my daughter took of the first pine seedling standing in the fresh soil with the cove behind it. Put everything back in order, returned it to the fireproof safe in the corner of the study. My daughter was in the kitchen when I came out. She asked what was in the folder. I sat down and told her everything: the easement, the history of the land, what Diane had built and why, what I had done and why I had waited, what it had cost, and what it had protected. She listened without interrupting once. When I finished, I handed her the folder the same way my father had handed it to me on my 18th birthday. She held it with both hands. I told her what my father had told me: if you ever lose this land, it won't be because somebody took it. That evening, I sat on the granite shelf with my grandfather's tin thermos beside me and watched the water move quietly across the cove. My daughter was swimming. The flag on the original dock, the one Henry Harlan Beaumont built board by board in the summer of 1958, moved slowly in the wind off the water. Here's what I want you to take from this, and I mean it as practically as I can say it. Go to your county clerk's office. Pull every recorded document attached to your property. Read every page. Because somewhere in that paper trail, someone who loved that land before you might have already done the work. They might have already won this fight for you. You just have to find it. Patience isn't passive. Documentation isn't paranoia. Silence isn't ignorance. And land doesn't care about ego. It only responds to what's actually written in the record. My grandfather put it in the record in 1962. 61 years later, it held. Every single word of it. If this story found you at the right moment, if you've sat across from an HOA board that treated your property like their personal development project, or been fined for things you didn't do, or watched a community get turned against you by someone with a clipboard and a patient smile, drop your story in the comments. And subscribe and hit the bell, because the next one is already on my desk. And it makes this one look quiet. They built 14 cabins on my shoreline, 14 full foundations, private boat launches, bronze address plaques on every door, 3 years of construction, $4.2 million, and the entire time I was sitting on a single piece of paper that made every single one of them illegal. I didn't say a word. The woman who greenlit the whole project, the HOA president who had been running this development like it was her personal real estate venture, she assumed my silence meant I didn't understand what I had, that I was just some quiet guy who inherited land and hadn't gotten around to figuring out what it was worth. She never asked, never checked, never pulled the original deed from 1963 that my grandfather recorded with the county clerk, the one with the shoreline easement that explicitly prohibits exactly what she spent 4 years building. So I let her finish. I let her sell memberships at $78,000 each. I let her take out a $2.1 million construction loan. I let her throw a ribbon-cutting ceremony with a newspaper photographer and a quote about maximizing the neighborhood's natural assets. And then, on closing day for the final 2 cabins, I walked into that title office with one piece of paper. This is what 61 years of preparation looks like. My father handed me a manila envelope on my 18th birthday. Original land deed, easement documentation, 2 survey plats, 1 handwritten note from my grandfather. I spent the next 22 years working as a contractor for the Army Corps of Engineers, surveying land rights for federal waterway projects. I know what a riparian easement is. I knew exactly what I had. She did not know that I knew. This land is called Harlan's Cove. My grandfather, Henry Harlan Beaumont, bought these 3.4 acres in 1962 with 15 years of railroad savings and paid cash. My great-grandmother waded into that water the first morning they owned it. My grandfather built the dock by hand, board by board, weekend by weekend. My father taught me to fish on the flat granite shelf at the water's edge. My daughter learned to swim here at age 6. 4 generations on the same shoreline. That's what this fight was actually about. Not square footage, not assessed value. That mailbox post with Beaumont still painted on it in my grandfather's handwriting. Let me take you back to where this all started, because you need to understand the ground before you can understand the fight. My grandfather walked into the county recorder's office on a Tuesday morning in September of 1962 with a cashier's check, a hand-drawn property sketch, and 15 years of railroad calluses on his palms. He wasn't a wealthy man. He was a maintenance worker who had spent a decade and a half laying track and saying no to everything he didn't need, so he could one day say yes to something that actually mattered. 3.4 acres along the cove. He paid cash, shook hands with the county recorder personally, drove home, and started building a dock the following weekend. The land itself sits in a natural bowl along the eastern shoreline. A ridge of old white pines behind it breaks the wind off the water. The cove is spring-fed, which means it runs cold and clear even in the dead of August, when every other body of water in the county turns warm and green. There's a flat shelf of granite at the water's edge, wide enough for 2 lawn chairs and a cooler, that my grandfather discovered on his first morning there and never stopped using. He built that dock before he even owned the land outright. He knew he was going to buy it, he just started building. But the dock wasn't my grandfather's smartest move. His smartest move was what he did at that recorder's office before he left. He filed a shoreline easement, a recorded right-of-way and access clause that ensured no upstream or adjacent property owner could ever obstruct, alter, or commercialize the natural drainage corridor feeding the cove. 2 pages, handwritten addendum, witnessed and notarized. He did it because 3 years earlier, a neighbor upstream had attempted to dam the creek that fed the property. Not out of malice, just carelessness. And Henry had to fight him off with nothing but a strong voice and a good attorney. He won. But he decided he would never need to fight that particular battle again. So he put it in writing. He put it in the county record. And then he went home and never mentioned it to anyone except his son. Here's what most people don't understand about easements like that one, and this matters, so stay with me. Riparian easements, property rights tied specifically to land adjacent to a body of water, are among the oldest and most legally durable protections in American property law. Unlike a zoning variance that a city council can overturn, unlike an HOA bylaw that 4 people can rewrite on a Tuesday night, a recorded easement runs with the land itself. It attaches to the deed. It survives ownership transfers, HOA reorganizations, municipal rezoning, and the passage of time. A properly recorded easement does not expire through non-use. It does not fade because nobody enforced it for a decade. It does not disappear because the person who filed it has been dead for 30 years. It just sits there in the county record, quiet, permanent, and waiting for the moment someone needs it. My grandfather filed that easement in 1962. My father inherited the land in 1991, maintained it quietly, paid his dues to the small 8-family association that existed then, and never had a reason to think about the easement at all. In those years, the HOA was barely worth mentioning. Road grading twice a year, a shared boat ramp at the north end of the cove, $45 a month. Nobody was building anything, nobody was taking anything. 8 families, everyone knew everyone, and the most controversial vote my father could remember was whether to repaint the ramp sign. They voted yes. That was the HOA. Then in 2014, the longtime president stepped down. A woman named Diane Harwick put her name forward. Nobody ran against her. Nobody took her seriously enough to bother. Diane was mid-50s, always in tailored resort wear, even on a Tuesday morning. She drove a white Range Rover that would eventually have a Crestwood HOA parking placard in the windshield, a placard for a community that didn't exist yet. She spoke in the measured, patient tone of someone who had been told no many times over many years and had quietly concluded that no was simply a starting position. She called herself a community advocate. Her LinkedIn still listed her as a real estate developer. Year one under Diane, dues tripled. A new Lakefront Development Committee was formed, which sounded reasonable enough that nobody questioned what it was actually for. And buried in item 7 of a 12-item agenda at the third meeting of that committee, in language that was careful and vague and easy to skim past, was the first written reference to cabin infrastructure along the eastern shoreline. Nobody flagged it. We are sitting on one of the most underutilized natural assets in the county, Diane told the 4 people in that room. That ends now. My father passed in the spring of 2019 after an illness that moved faster than anyone expected. He had updated his will 8 months before he died. I've thought about that timing more than once, whether he sensed something coming or whether it was coincidence. I've never been able to decide. The land transferred to me without complication. What took more time was going through his study, his desk, his books, the filing cabinet in the corner, and in the fireproof safe behind the cabinet, a manila folder I recognized immediately, the same one he had handed me on my 18th birthday, thicker now with documents added over the years. Inside, the original 1963 deed, the easement documentation with the handwritten addendum, county recorded and witnessed, survey plats from 1963 and 1978, and underneath everything, in an envelope I had never opened, a note in my grandfather's handwriting. 4 words: don't let them take the water. I called a property attorney the following week. She reviewed the easement documentation and called me back the same afternoon. Valid, recorded, fully enforceable. The easement explicitly prohibited, in its original 1962 language, commercial structures, permanent alterations to drainage corridors, and privatization of shoreline access within the defined riparian zone. The riparian zone, as surveyed in 1963, covered the entire eastern bank of the cove. The entire eastern bank. The same ground Diane Harwick had been eyeing since the day she took that board seat. I attended the next HOA meeting, sat in the 3rd row. Diane stood at the front of the room and unfolded a poster board, full-color renderings of Crestwood shores. 14 lakefront cabins, a paved access road, a private boat launch for each unit. She was proud of it. The room applauded. I looked at the renderings for a long moment, looked at Diane, smiled politely, renewed my dues on the way out, said nothing. The permits started appearing in the county system in early 2020. I checked every single one. Filing dates, parcel references, contractor names, scope descriptions. I was looking for one specific thing: any disclosure of the recorded shoreline easement in the permit applications. It wasn't there. Not in the first filing, not in the second, not in any of the 14 individual structure permits that followed over the next 2 years. Every application moved through the county process cleanly because nobody on the permit side thought to pull the underlying deed history, and nobody on Diane's side gave them a reason to. The first cabin went up in spring of 2021. Prefabricated panels, efficient crew, done in under 3 weeks. By midsummer, there were 3. By fall, there were 6. Diane held a ribbon cutting for what she was now officially calling the Crestwood Shores Community Retreat. Local newspaper coverage. A quote about maximizing natural assets. A small crowd of members who genuinely believed they were watching something good being built. Then they rerouted the drainage corridor. I wasn't there when it happened. I came down to the water one morning and the excavator had already been through. The channel that had fed that cove since before my grandfather bought the land, the corridor explicitly protected by a 61-year-old recorded easement, had been redirected 20 yards east to make room for a cabin foundation. And 11 white pines, mature trees that had stood along that corridor for decades, were on the ground. Cut. Gone. In a single afternoon. I walked to the granite shelf, the shelf where my grandfather taught my father to fish, where my father taught me, where I taught my daughter. A freshly poured concrete boat launch now partially blocked it from the water. I stood there for a while. I didn't say anything to anyone. I took out my phone and took a photograph. I let them keep building. Because in property law, there is a concept called damages. And damages multiply with every nail they drive. By early 2023, 12 cabins were complete and 2 were under active construction. Diane had pre-sold memberships to all 14 units at $78,000 each. $19 million in membership revenue collected and spent. Projected annual rental income from the completed units was sitting at $280,000. On paper, Crestwood Shores was a success. A neighborhood real estate play that had gone exactly according to plan. The construction loan was $2.1 million, secured against the community lakefront property. The regional bank holding that note had conducted their own due diligence before issuing it. What they had not done, what nobody in that entire transaction had done, was pull the original 1963 deed and read every page of it. The easement was not on their radar. They had no idea it existed. Here's why that matters enormously. When a lender finances construction on land encumbered by a valid recorded easement restricting that specific use, the lender's security interest is legally subordinate to the easement. That is not a technicality. That is the fundamental structure of property law. In plain language, if the development is found to violate the easement, the bank's collateral, the cabins, the boat launches, the paved road, all of it, loses the majority of its appraised value. The loan can be called. The lender becomes a creditor chasing assets that courts have already legally compromised. I had researched this thoroughly. I had a folder. Closing day for the final 2 memberships was scheduled for March 14th, 2023. A young couple and a retired contractor, each paying $78,000. The HOA planned to apply those proceeds directly against the construction loan balance. I circled March 14th on my wall calendar. My daughter noticed the marking and asked what it was for. I smiled. A meeting. Meanwhile, Diane had been watching me for months, or rather, watching for a reaction from me and not getting one. No letters, no phone calls, no attorney correspondence, no appearances at board meetings to raise objections, no county complaints, nothing. A year and a half of construction on my shoreline, and the man whose shoreline it actually was hadn't made a single sound. In a person with better instincts, that silence might have triggered caution. A quiet neighbor in a property dispute isn't always an uninformed one. Sometimes quiet means waiting. Sometimes quiet means they already know something you don't. Diane didn't have those instincts. What she had was a developer's reflex. When the other side isn't pushing back, you push forward. She read my silence as ignorance, and then she decided to convert that ignorance into paperwork. The first letter arrived in November of 2021, on formal HOA stationery with an attorney's signature at the bottom. It asserted that a strip of my shoreline property, the narrow band running directly along the eastern bank, had been incorporated into the Crestwood Shores common area through adverse use. Adverse use. She was claiming squatters' rights on land my grandfather had purchased outright in 1962 and my family had maintained continuously for 6 decades. The legal theory required, among other conditions, that the use be open, hostile, and uninterrupted for a statutory period. None of those conditions existed, not one. I read the letter twice, called my attorney, and we both laughed briefly before we got to work. 2 weeks later came a formal maintenance access request, standard HOA language about inspecting shared infrastructure, except that when Diane arrived, she brought a clipboard and a man she introduced as their surveyor. I asked for his state registration number. She said she didn't have it with her. I asked him directly. He gave me a name but could not produce a license number or a verifiable firm affiliation. He had survey equipment. He did not have credentials. I asked them both to leave and made a note of the date, time, and the vehicle they'd arrived in. She thought silence was surrender. She had no idea it was strategy. The fines started in January of 2022. $150 for an unpermitted structure on my property. The structure in question was my grandfather's dock, the same dock Henry Harlan Beaumont built board by board in the summer of 1958. The same dock that had been standing on that shoreline for 64 years, grandfathered under county code that predated the HOA's existence by more than a decade. I read the notice carefully, filed it in a folder I'd started keeping specifically for correspondence from Diane. Said nothing. February brought a $200 fine for shoreline vegetation alteration, claiming I had trimmed grass and removed vegetation along the bank without HOA approval. I had done no such thing. I hadn't touched the bank, hadn't been near it with any cutting tool in the preceding 12 months. The fine was fabricated from nothing and delivered on official stationery with the same administrative confidence as if it described something that had actually occurred. I filed it behind the first one. April was my personal favorite. $350 for failure to maintain easement corridor access. Read that again. The organization that had rerouted a protected drainage corridor, cut 11 trees from a county habitat designation, and poured concrete over a mapped wetland buffer was fining me for obstructing an easement corridor. The irony was so complete it almost felt deliberate. It wasn't deliberate. It was just Diane running a playbook without reading the property history underneath it. Filed it with the others. By mid-2022, the fabricated fines had accumulated to $3,800. Then came the threat, formal notice that if the balance remained unpaid, the HOA would move to place a lien against my property. I attended the next board meeting. Diane addressed the room about my non-compliance with her usual measured confidence. When she finished, I said, "Noted. Thank you, Diane." Sat back down. What Diane didn't know, what most homeowners don't know, is that HOA fines cannot legally be converted to a property lien in most states without a formal judicial process and documented proper notice. Many HOAs threaten liens routinely, counting on residents not understanding that a threatened lien is not a recorded lien, and that a lien filed in violation of state statute is legally voidable. The threat was a bluff. I paid nothing. Then came the social campaign. Anonymous posts started appearing in the neighborhood Facebook group. No profile photo, account created recently enough that it had no history. But the writing style wasn't difficult to place. The specific cadence, the particular way certain words were chosen to sound reasonable while landing as accusations. I had been reading that writing style in HOA meeting minutes for 3 years. The posts described me as difficult, uncooperative, someone holding the community back from something genuinely good. One post, the most calculated of all of them, claimed I was in private negotiations to sell my property to an outside developer, and that my resistance to the HOA was designed to protect that deal. It was a lie constructed with a specific purpose, to reframe me not as a property owner defending his legal rights, but as a saboteur with a financial motive. To make my neighbors afraid of what I might do, rather than curious about what Diane had already done. It worked on some of them. 2 men whose families had known mine for decades began keeping their distance. No confrontation, no conversation, just a gradual cooling. A shorter nod from the driveway, an unreturned wave. Dave, who had fished with my father every spring for 20 years on that same cove, stopped making eye contact when our vehicles passed on the gravel lane. That one was harder than the fines, harder than the fake surveyor, harder than the attorney letters. My daughter was visiting for a weekend when she found the posts. She read through them at the kitchen table, and her face went through several expressions before settling on fury. She wanted to respond publicly, correct the record, call it out by name. I put my hand on her arm. Let them talk. Every post they write is evidence of a pattern. Screenshot it. She screenshotted everything. Then came October of 2022, the morning I came back from a run to find 2 men on my property. Not near the boundary line, not on the shared access lane. On my property, inside the tree line along the eastern bank. One had a tripod and survey equipment set up approximately 40 feet from the water. The other was standing at the edge of the corridor protected by the easement, photographing it with his phone. I watched them for a moment, then I walked over, asked calmly who had authorized the survey. Neither of them could produce a license number, a firm affiliation, or any documentation connecting them to a licensed surveying operation in this state. Leave my property now. Before either of them reached the boundary line, I had photographed both of them, their equipment and their vehicle, a white SUV with a Crestwood HOA logo on the driver's side door. I noted the plate number, noted the time. That afternoon, I drove to the county sheriff's office and filed a formal trespass complaint. The deputy reviewed the HOA's authorization letter, which the men had left behind in their hurry to leave. He read it twice. The letter cited a specific HOA bylaw as the basis for the access. That bylaw contained no language authorizing entry onto adjacent private property under any circumstances. The deputy looked up from it with the expression of a man who had seen this kind of thing before and had not grown more patient with it over time. The complaint went into the record. That was the moment I stopped treating this as something I was observing and started treating it as something I was building a case around. I pulled every document I had accumulated over the previous 2 years and organized it. Every HOA letter, every fabricated fine notice, every Facebook screenshot my daughter had taken, every permit number pulled from the county system, every date, every name, every dollar amount. The trespass report went on top,